Well, this is a pre-recorded radio interview with Joe Karp of Karp Law Firm, and we're going to certainly have a very informative discussion that we usually do, but I think this is, when I first saw this article, I said, what do you mean divorce your spouse to afford nursing home care? So, Joe, I mean, that's pretty serious stuff.
Yeah, there's a common misconception, which is because Medicaid looks at the assets of a husband and wife, when one of them applies for nursing home Medicaid or home care Medicaid, they assume, or assisted living Medicaid, they assume automatically that the only way the healthy spouse can preserve assets is through divorce. And in many states, that's actually what happens. People do what's known as Medicaid divorces, and many of your listeners may even remember hearing about friends from New York or New Jersey where one of the parents got sick, and the only way they could protect the assets is there was a divorce between a married couple that had been married, 50 years, 60 years, 40 years, so that in the divorce decree they could give all of the money to the community spouse, the one that's home, and impoverish the person who went into the nursing home. But of course, they wouldn't be the spouse, it would be the ex-wife or the former husband. And that was commonly done. So when they said, well, how much do Mr. and Mrs. Jones have? Well, they say, well, they got divorced. Mr. Jones got all of the money in the divorce, and Mrs. Jones is now broke, and she's in the nursing home. And they did that to accommodate Medicaid eligibility, which is just morally and psychologically horrible.
Right.
But when people had to make a decision, I can't care for my loved one at home. I either go broke paying my money down until we can protect the money, and I can just have a modicum of money left, or I can do some Medicaid planning, and one of the ways was divorce. And for years, that's what happened. But in Florida, we have a unique situation on multiple counts. First of all, in Florida, unlike New York or New Jersey, the homestead is safe. So the husband and wife can own the house, and no matter who's in the nursing home, the money is safe. The value of the house is safe. And we could transfer it from the husband to the wife without a divorce, or vice versa. And the community spouse could keep the house and keep the money when the house is sold. And even when they die, if somebody's been on Medicaid, if they leave the house to the kids, the house is safe. And the proceeds of the sale of the house when the kids sell it is safe. So Florida is a wonderful state for that. But the big thing is Florida has something else that most states do not have. It's called spousal refusal. And it has nothing to do with a headache. Spousal refusal has to do with both federal and state law. The federal law says if somebody is applying for Medicaid and they're in a nursing home and they have a community spouse, there's an amount of money that the community spouse can have. And that amount is $117,000, actually $117,240. That doesn't count the house. And that's now the number. But the question is, suppose you have a married couple. The wife is 75, the husband is 80, and he has to go into a nursing home. And they have $300,000, $400,000. And they have modest Social Security incomes, and they live within their means. But they tip into the till in order to survive, and they know when one of them dies, one of the Social Securities is going to be gone. And there's a great concern, which is, how can I protect this $400,000 so I'm not down to $117? Because if you're a 75-year-old lady today, you plan on, realistically, you probably have another 20 years to go. Certainly 15. So you're saying, how can I live on this if I'm going to have to pay a nursing home almost $9,000 a month? How am I going to survive? I'm going to get all the way down to 117. This is horrible. What can I do? Well, Florida has a law called spousal refusal. Let me tell you how it works. Number one, we can transfer all of the money to the husband, from the husband to the wife, or vice versa, obviously. But say the husband's one in the nursing home. We can transfer it, and say he's in today, and say he's been in for 2 weeks. But we haven't applied for Medicaid yet. And the wife comes in to me and says, what can we do? We can say, well, you can transfer all of your husband's money to you. And the immediate reaction is twofold. One, isn't there a look-back period and a penalty as a result? And the answer is yes and no. Yes, there's a look-back period. Medicaid will look back 5 years for transfers. But there is no penalty imposed. Transfers between a husband and wife have no penalty. So although he was in the nursing home 2 weeks ago, we transferred all the money to the wife today. There's no penalty for that transfer. The second problem is obviously $400,000 exceeds $117,000. How do we get past that threshold? What's the new math, Joe Karp? There is no new math. Under federal law, if the paperwork is all in order, the community spouse can then sign papers that says, I refuse to use my money to pay for my institutionalized spouse's care. And I'm talking about even if your community spouse was, the institutionalized spouse has already been in the nursing home and the transfer occurred today, and we're applying tomorrow. I'm not giving my money. Yeah, it was his yesterday. He gave it to me. It's now mine. I'm not sharing it with him. And under federal law and state law, if that's done, and if all the proper paperwork is in order, that spouse can then get Medicaid for the person in the nursing home and keep the $400,000. And it
Joe, is this new?
Works.
Is this new?
No. No, it's been around over 10 years in Florida. And Florida is a uniquely wonderful state for it because there's certain paperwork and I's and T's that got to be crossed and dotted. And there's certain things people should understand. Number one, it only works if the person was otherwise eligible for Medicaid. So if they gave the kids $300,000 last year, we got a problem, don't we? Because we have this big gift that will not affect Medicaid eligibility. So it only works if the person was, quote, otherwise eligible for Medicaid. The other interesting thing is under federal law, certain forms have to be signed, so you have to make sure that the person who's power of attorney for the institutionalized spouse has the right to transfer the money, even if it's my wife transferring our money to her, that she has paperwork that says she can do it. Two, that she has the authority to sign the kind of forms that the government requires that she sign on my behalf. Because the feds say the state must have the right to go after the community spouse as if they were standing in the institutionalized spouse's shoes, which means, again, if mama's the one who's home, the state of Florida has to be given the right to sue mama as if they were me, as if they were dad, to get paid back. Now, here's the interesting thing. So in New York, they have spousal refusal, and the state absolutely would chase the community spouse or the wife or the husband who's home to try to get them to contribute towards the cost. And they legally can do it, and they do it. In Florida, There was a Supreme Court of the state of Florida case in 1995 that said, strangely enough, there is no duty to provide your spouse with medical necessities. It was a 1995 case, December 1995. It had nothing to do with Medicaid. It had to do with a hospital suing a widow after her husband died. And they said there's no duty to provide your spouse with medical necessities. Well, remember what I said is the state stands in the shoes of the husband, if you will, in this case. Well, what are his shoes? His shoes are empty because he has no right to demand that his wife pay his medical bills. So in Florida, the state does not pursue even recovery from the community spouse. It works. Now, there's a number of steps, and you've got to dot every I and cross every T. You've got to make sure all your paperwork is in order and the person is otherwise eligible for Medicaid. You can't just walk into the lawyer and say, well, my husband has had Alzheimer's for the last 9 years, and I decided to put him into the nursing home today because he doesn't know anything, he can't say anything, he's unable to communicate, he's totally incompetent. And I'll say, well, do you have a power of attorney that authorizes you to make these gifts to yourself? No. Do you have the ability to sign the paperwork assigning his interest to the state of Florida to file the claim? Even though the state will not be able to prevail, that's still an I and T that have to be dotted and crossed? No. Well, then you can't get it. So people have to plan and prepare. Did you do any gifting? Yes. Well, that gifting may impact on Medicaid planning and eligibility. But this absolutely works. So we have the beauty of telling people, and this is absolutely the gospel, we've never had clients get divorced for Medicaid. But we have had 8 couples get married.
For what?
To get Medicaid, because they were living together. We had one couple who had been living together for 19 years and had been married 40 years ago. After 20 years, they got divorced. They continued to live together because they never separated. 19 years later, he ended up needing a nursing home. He was still cognitive. He had physical issues. He was aware and alert. They got married, and he was then able to transfer all of his money to his wife. Had she been just his significant other, he couldn't have. And they did spousal refusal. So it absolutely works. So I've had people who have lived together always saying, oh, we'll never get married because of Medicaid and because of this stuff, who've actually gotten married. Now, I haven't performed any of the ceremonies, but they've actually gotten married so they could do the transfer, which between a husband and wife is legitimate, yet is not legitimate between a boyfriend and girlfriend, regardless of the age. So it is an option for people, and people who think, and there's a couple of reasons. Sometimes you say, well, my husband won't end up in the nursing home except over my dead body.
Right, that's what they say.
And number one, this also takes care of how to protect it if everything's transferred. And I've had a couple of cases like that where we've done the transfers to the community spouse or the purported one, and they kept the husband home, and the wife died while they were home, and then the wife had all the money, and we were able to protect the money for the husband, and there's ways to protect the money so that when she died, he was legally broke, and the kids were able to put him in a nursing home because he couldn't stay home alone. I've even had one client who, when the husband died, the wife, who was still home, it was a case that they were planning, and he was a caregiver, and he said, oh, she's going to have to go in when the long-term insurance runs out. And he was her caregiver, and he had part-time care at home. One day he went out to Albertsons, which was still in business here, and he'd taken his groceries back from the store into his car. And as a caregiver, for any of your listeners who are caregivers for Alzheimer's patients know, He was totally distracted. He wasn't focused in.
Mm.
He was hit by a pickup truck, and he was killed.
Oh, heavens, Joe.
He was killed. I mean, caregivers go first for any number of reasons, including lack of attention to detail.
But, Joe, what all this says to me is why people must go to an elder law, board-certified, especially, elder law attorney. You can't go to your friend who's a real estate attorney. You can't go to your friend who's been dealing in stocks. You can't go to your brother-in-law, your son. Everything that you say, I sit here in the studio with my mouth open saying, how is he going to knows all this?
In that case, by the way, just so we're clear, not only was the money, when he died, Mom had been living at home. The kids all lived in Westchester, New York State. They flew Mom, and we had already deeded the house to Dad. They flew Mom up to New York. They put her in the Hebrew Home for the Aged in Riverdale, and she was able to get Medicaid in New York. And all of the money that Dad had was properly done and protected. And there's some, I don't want to go into all the technicalities of what we had to do, but the money was protected for her and from the government, and all legitimately, all above board, all with full disclosure. And some of that money was used on private duty care to assist Mom while she was on Medicaid in New York. And the thing people have to understand is, we've been doing this for 20 years. We've been doing this for 20 years, so we know every angle. We know what's kosher. And by the way, I won't do spousal refusal for everybody. I'll say to people, you have too much money. You don't need to do it. You're making a tax mistake, or you don't need to do it because you're going to be a red flag for the government. I've never seen it turn. Someday some pig is going to get slaughtered because they're going to try to do it with $5 million. And technically you can, but if you want to, this is for people who are of modest, comfortable means. This is not to help millionaires take advantage of the system. It's to help middle-class families survive. It's to help the middle class survive. It's critical. And they need to go to somebody who's certified, knowledgeable. I don't mean to ever say anything negative about other lawyers, but a lot of lawyers today say they're practicing elder law, and I see stuff that they're doing that makes no sense. And sometimes they're even getting people Medicaid. But, for example, I had somebody get Medicaid, an opportunity. A lady came to me and said she had heard about spousal refusal. And she came in and said she met with a lawyer and wanted to know if spousal refusal really worked because her friend said, no, it didn't work. You better see Joe Karp. Came in to see me, and I said, it absolutely does work, and I explained it. And then we went over her scenario. Her husband had 6 months or less to live. He had $500,000 in a 401k. The lawyer's advice was, cash in the 401k and we'll transfer the proceeds to you. And I said, hello, lady. Your income tax on $500,000 is going to be $200,000. Because when you cash it in, we got an income tax consequence. Your husband has less than 6 months to live. Why would you pay $200,000 in taxes to save potentially $50,000? And it wouldn't have even been that much because his Social Security would have gone to the nursing home. So sometimes, although people are getting answers that are technically correct, they fall in the face of logic and good planning.
Well, let me ask you. Yeah, well, let me ask you. In your seminars, we ought to talk about your seminars. Do you talk about things like this?
Absolutely. We absolutely discuss spousal refusal. Absolutely.
Okay, so I want to tell everybody that we have seminars coming up. There's one on Tuesday.
We're back.
Yeah, we're back. Tuesday, October the 7th, which is going to be in Port St. Lucie from 1:30 to 4. And then Wednesday, October the 8th from 1:30 to 4 at the Courtyard by Marriott in Boynton Beach. And then Thursday, October the 9th from 1:30 to 4 at the Palm Beach Gardens Marriott. And reservations are not required. If you have any questions, you can call their number, which is 1-800-893-9911. Or you can always go, and that's a good thing to do no matter what, go to their website. It's quite complete. It's with a KARPLAW.com, karplaw.com. And I think you said that you were only going to do one of them this time?
Yeah, Jenny Bernstein, who's a board-certified elder law attorney who's with the firm 10 years, is doing the Port St. Lucie one as she always does. I'm doing Boynton Beach. And because Thursday afternoon I have to drive up to Orlando because I'm attending a 2-day seminar all day Friday and all day Saturday, or half a day Saturday, and I don't feel like driving up after a seminar, Jenny's going to be also doing the Palm Beach Gardens seminar and workshop. And at that workshop, she does a bang-up job. Everybody loves her. She's board certified. She's been doing this stuff as long as I have. Well, not as long as I have, but with me for 10 years. And together, our office works as a team, and she'll be there doing it, and we'll offer anybody who shows up who we believe we can help will be offered a free consultation. So if you don't want to go to the workshop and you want to pay $400, you can call up and we'll give you a $400 consultation, or you can go to the workshop, get a whole bunch of information, and then you'll get that $400 consultation for free. So it's beneficial, and we'd love for people to come. We didn't do one since July, so we've been not doing seminars the entire seminars this summer. We didn't do August or September. So we're back, and we're doing them in October, and we'd love people to come up, and we can talk to them. And, of course, we're going to talk about traditional estate planning issues and what everybody has to know, because people's estate plans are so out of whack and so out of date. With the changes in the tax laws, so many people have estate plans that are loaded with tax planning that they don't need. They have so much stuff that's out of date, and their cast of characters is out of date. And one of the things we always like people to know is our clients are always invited every 3 years to come back for a free review because it's important. And if they have to change documents, they do it, and they'll pay a fee for that. But we're getting more and more people who are realizing how important it is to change things, that they should review it. We got one call this past week where a client had been asked to come in every 3 years, didn't come in. He did his estate plan 10 years ago, goes into the hospital, he's very sick. That's when he finally thinks about the fact that his cast of characters to make his medical decisions is no longer appropriate. And he was cognitive, but he had named his girlfriend, who 10 years ago was sharp as a tack. Now she was not so sharp, inappropriate, not the right person. And so people should always be looking at their plans and having them reviewed. And that applies to people who show up at our workshops. If you already have a plan, even if we didn't do it, especially if we didn't do it, here's a chance for a free second opinion.
Yes, that's excellent. Well, Joe, let me ask you a question. You've been practicing law for, I want to say, 30 years?
40 years.
40. What are the highlights of being an elder law attorney? Can you pick out one? What is the thing that you like the most?
The thing I like the most is the hugs I get, people who are in dire straits, when I've altered their life because I've been able to preserve assets for a person while their husband or wife is going into a nursing home. And that they're petrified. We just had a lady right now, and it's a complicated matter, but her husband needs to go into a nursing home. There's $7,000 a month income for him, and she was told, "You're screwed, lady." and we were able to legally, above board, with full disclosure, get all of his income transferred to her. He will get Medicaid. She will have that money to live off of. And they don't have much in savings. They didn't need my help to stay below the $117,000 because he had a very large income. So they didn't need large savings. But that woman just hugged me, cried, and said, "You've changed my life." Because she saw her life being abysmal. She was either going to have to pay $9,000 to a nursing home or keep her husband home, paying for help, seeing the money go down the drain, not being able to provide him with the quality of care he needs, and suffering in her own life because of the difficulties she was facing as his caregiver. That's,
that must have made you feel good.
Yeah. I stay around for those thank you mass men. I love it.
I'm sure you do.
When I get the thank you and the hug, that's wonderful. And it really makes me say, I'm glad I'm a lawyer. I'm glad I can do elder law. I'm glad I can help people. I mean, there's other things that we do to make sure in our traditional estate planning that we keep families harmonious and stuff like that. But when you can alter one individual's life like that, you go home and you say, wish my folks were alive to see it. They'd be really happy.
Yep, I know. I know that about you. I know that you're really very, very, you're compassionate, you're sensitive, you're very smart, and you're very experienced. So how anybody would not be calling you, I don't know. But just go to one of Joe's seminars. Again, it's October 7th, the 8th, the 9th. But just get on their website. It's karplaw.com with a K. Thank you, Joe. I certainly appreciate your taking the time to do this with us today.
You're welcome, and happy holidays.
All right. Thank you. Thank you. Bye, Joe.
Bye-bye.